Hi, good morning. Today we are going to analyze some problem questions. Question on the Sexual Offences Act 2003. The video content has been made available for informational and educational purpose only. Kindly go through the slide completely. We have to discuss whether G, I, J, and T could rely on the consent of the complainant if charged with the Sexual Offences under Sexual Offences Act 2003 in the following situations. We are going to analyze the question and answer one by one. G and Sophie meet at the nightclub. When they finish dancing, G invites Sophie back to his flat for a drink. After they enter the house, G locks the front door and put the key in his pocket and says, "No escaping now." Sophie wants to leave, but she is frightened. Sophie does not say anything and submit to intercourse. Under Section 74 of the Sexual Offences Act 2003, Sophie must have the freedom to choose whether to engage in the sexual activity. The G actions of locking the door and declaring "no escaping now" suggest a corrosive environment. Sophie's submission to intercourse, motivated by fear rather than a genuine agreement, indicates an absence of consent. In R versus Olubja case in 1982, the court distinguished between the submission and consent, emphasizing that submission induced by fear does not amount to true consent. The evidential presumption under the section 75(2)(d) might apply here, as G's action created a situation of fear. If Sophie's a lack of resistance is interpreted as consent, it will fall to the jury to determine whether her submission was voluntary under Section 74. In other words, G's action towards Sophie raises significant issues regarding the consent. Under Section 75(2)(c) of Sexual Offences Act 2003 SYA, this is a rebuttable presumption that consent is not given if the complaint is unlawfully detained. G locking the door and saying "no escaping now" clearly indicates a Sophie's detention, which suggests she did not have the freedom to leave. The legal concept of unlawful detention applies here, as Sophie was effectively restricted from leaving the property, which forms the basis for the presumption under some section 75(2)(c). Additionally, Olubja case in 1982 highlights the distinction between the consent and the submission. Sophie did not express any verbal consent and was frightened, meaning her action could be interpreted as submission rather than a voluntary agreement to engage in sexual activity. A Sufi's submission to intercourse under duress or the fear is not the same as valid consent under Section 74 of the Sexual Offences Act 2003, which requires agreement by choice and the freedom to make that choice. Therefore, it is unlikely that G could rely on Sophie's consent. Ilya is hosting a group of friends, including Tina, whom he is very attracted to. Tina does not normally drink alcohol and asks Ilya for a juice. Ilya pours Tina a drink which is secretly laced with vodka. Ilya is hoping the alcohol will loosen Tina's inhibitions. Unaccustomed to alcohol, Tina becomes intoxicated and she and Ilya have enthusiastic intercourse throughout the night after others leave the party. In this scenario, the China's capacity to concern is undermined by intoxication. Section 74 requires the complainant to have the capacity to make an informed choice. Tina, unaccustomed to the alcohol, become intoxicated due to Ilios' deliberate lacing of her drink with vodka. In R versus Bree case in 2007, the court held that if intoxication prevents a person from making a free and informed choice, there is no consent. Although Athena appeared enthusiastic, her intoxicated state raises significant doubts that her capacity to consent. Moreover, Ilias' intent to manipulate Tina's decision making by intoxicating her demonstrate a clear disregard for the principle of genuine concern. In other words, Ilya's action is in secretly lacing Tina drink with the vodka raises the issue of voluntary intoxication, which can vitiate concern under Section 75(2)(d) of the Sexual Offences Act 2003. This provision presumes that Tina did not consent due to her intoxication. In R versus Bree case, the court ruled that while intoxication may impair one's capacity to concern, it does not automatically negate consent unless the complaint loses the ability to make the decision. I will repeat, in R versus Bree case, the court ruled that while intoxication may impair one's capacity to concern, it does not automatically negate consent unless the complaint loses the ability to make the decisions. So in this case, Athena became intoxicated after drinking a beverage with alcohol, and while she's engaged in intercourse with Liam. The question remains whether her capacity to concern was impaired. If Tina was still capable of understanding the nature of her actions and freely consenting, she might reboot the presumption under the section 75(2)(d). However, if she was significantly impaired and lacked the mental capacity to concern, as suggested by her unaccustomed to alcohol, then her concern would be invalid under the section 74. The fact that she had enthusiastic sex could be taken as an evidence of her having regained her capacity to concern, but this would depend on the extent of her intoxication at the time. Therefore, a nuanced examination is necessary to determine whether Tina had the capacity to concern when the sexual activity occurred. Grace is invited to routine vaginal examination at the clinic. Jonas introduces himself as a doctor and performs the examination while becoming sexually aroused. Unbeknown to Grace, Jonas is a trainee nurse and is not qualified to perform any examinations. Jonas misrepresented his qualification, leading Grace to believe he was a doctor. Section 76(2)(a of Sexual Offences Act 2003 creates a conclusive presumption of lack of consent if the defendant intentionally deceives the complainant as to the nature or the purpose of the act. The case of R versus Tabasum in 2000 is instructive whether a definite, a false claim of the medical qualification render the compliance concerned invalid. Here, Gray's concern to medical examinations not to sexually not to sexual activity performed under the false pretenses. Jonas' deceptions undermines a Gray's ability to give informed consent, rendering it invalid under the section 76. In other words, Jonas' action constitutes deception about the nature of the act, as he misrepresented himself as a doctor when he was actually a trainee nurse. Section 76 of the Sexual Offences Act 2003 provides a conclusive presumption against the consent if the complaint is deceived as to the nature or the purpose of the act. In R versus Chabasam case in 2000 is directly applicable here as it establishes that if a person deceives the complaint about the nature of the act, such as pretending to be a qualified doctor, performing a legitimate medical examination, the consent is valid. Jonas decides regarding the qualification and the purpose of the virginal examination, vitiates agrees concerns under the section 76. This is a clear example where the complaint was deceived about the nature of the act, and this deception directly impacted her ability to give informed consent. Therefore, Jonas cannot rely on Gray's concern to justify his actions. Let's move on to the question, the final scenario, question 4. The scenario 4, the Charlie is a famous singer who was adoring fans around the world. One evening, after a concert, Josie, who had been in the audience, approaches Chandy to say how much he enjoyed the gig. Chandy tells Joyce he has instantly fallen in love with her. Chandy says Josie is his soulmate and that Josie should come and join him on the tour. Josie is overjoyed with affection and a chance to see the world. Chandy invites her to his dressing room where Josie agrees to have intercourse with him. Afterwards, Chandy kicks her out and says he does not want to see her again. Stanley's a false declaration of love and promises of a shared future do not necessarily vegetate as Josie is concerned. Section 76(2)(a) only applies where deception concerns the nature or the purpose of the act. In R versus Gita, 2007, the court held that general lies or emotional manipulation do not fall within the ambit of the section 76 unless they relate to the act's nature or the purpose. A Josie is a concern to sexual activity without correction or the misrepresentation about the act itself. However, under Section 74, the court may assess whether Tony deceitful conduct affected Josie's freedom to make an informed choice. Ultimately, this scenario hinges on the jury interpretation of the Josie's subjective experience and whether Tony's manipulations undermined her freedom to the concerned. In other words, in this case, the Chandy's action do not seem to involve any of the evidential presumptions under the section 75 or the 76 of the Sexual Offences Act 2003, but rather they involved the issues of concern under section 74. A chant is a declaration of love and the promise of glamorous life on the tour created an emotional context. But this is not considered deceptions related to the physical act of sex itself. In All versus Lawrence in 2020, they clarified that deception regarding the circumstances, such as the one's intention or the background, does not necessarily vegetate concerned unless it directly pertains to the nature or the purpose of the sexual act itself. Josie's concern was likely influenced by the emotional and romantic context, but since the act of intercourse was not the result of the fraudulent representation about the act itself, authority cannot rely on Section 76 to invalidate Josie's concern. Instead, the key question would be whether Josie freely consent to the act under the Section 74 of SOA. If Josie's consent was obtained under emotional manipulations, it may still be valid, but this would depend on whether the emotional pressure amounted to corrosion or the undue influence which would affect her ability to consent freely. Each scenario demonstrates different challenges regarding the validity of the consent under the Sexual Offences Act 2003. G and J are unlikely to rely on consent successfully due to corruption and deception, respectively. Elia's deliberate intoxication of the teenage undermines her capacity to concern, while T's action, though morally referenceable, may not negate Josie's concern under the statutory framework. These align with the relevant statutory provisions of case laws, including R versus Olipjaw, R versus Bree, and R versus Tabasum, to address the nuances of the concern in each context. In summary, the concern in each scenario must be evaluated under the specific provision of the Sexual Offences Act 2003. In G and S case, the presumption of non-consent due to unlawful detention and Sophie's submission under the fear makes it unlikely that G could rely on consent. In Ilias and Tina's case, the intoxication presumption under the section 75(2)(d) must be carefully considered to determine if Tina had the capacity to concern. In J versus G's case, Jono's assumption as to his qualification dictates G is concerned under section 76. Finally, in T and J's case, while T's emotional manipulation is concerning, it does not meet the criteria for deception under the section 76, and the issue of whether Josies are freely consented under section 74 remains central. Thank you.